You know that classic scenario, right? A totally bizarre accident happens and literally nobody saw a thing. How in the world do you prove who was at fault? Well, it turns out the law has a pretty ingenious and fascinating solution for proving negligence even when there's no smoking gun.
So picture this. You're just walking down the street, minding your own business, and all of a sudden, something falls from a building and injures you. You look around. Nothing. Nobody. No witnesses. No cameras. You know someone has to be responsible, but you have zero direct proof. Seems like an impossible spot to be in, doesn't it? Is the case just over before it even starts?
Well, not necessarily. You see, the law really works with two main types of evidence. On one hand, you've got direct evidence. That's the classic eyewitness, the I saw it with my own two eyes testimony. But honestly, that's rarer than you'd think. Much more often, cases are built on what's called circumstantial evidence. This is the stuff that doesn't directly prove something, but lets you connect the dots. You know, like seeing long skid marks on a road after a crash. You didn't see the person speeding, but those marks, they sure do tell a story.
So this brings us to the big question. What happens when your entire case is built on those kinds of inferences? How do you make an argument when all you can really say is, come on, this kind of thing doesn't just happen by itself? This is exactly where a special legal tool comes into play.
It's a Latin phrase, and it sounds kind of complicated, but the idea behind it is just beautifully simple. Res ipsa loquitur. It literally means the thing speaks for itself, and that's exactly what it lets happen.
At its heart, res ipsa loquitur is basically a superpowered form of circumstantial evidence. It gives a court permission to say, you know what, the way this accident happened is enough on its own to suggest someone was negligent. It's the law's way of acknowledging that some events are just so weird, they practically scream that someone messed up.
Now, of course, you can't just claim this for any old accident. Courts have a very specific checklist to figure out if a situation truly speaks for itself. So let's break down the 3 key tests a plaintiff has to pass.
Okay, so first, the event has to be something that just doesn't ordinarily happen unless someone was being careless. Second, the evidence has to point to the defendant as the one probably at fault, usually meaning they were in control of whatever caused the injury. And third, you have to show that you, the plaintiff, didn't do anything to cause your own injury. If you can check all 3 of those boxes, you might just be in business.
So what does this actually look like in the real world? The absolute best way to understand res ipsa is to see how it's been used in some really famous cases that shaped the law, from way back in the 19th century all the way to modern hospitals.
Let's start with the one where it all began, a case from 1863 called Byrne v. Beadle. A guy named Byrne is walking past a flour warehouse, and a barrel of flour just falls out of a window and hits him. He had absolutely no idea how it happened, and he couldn't point to a single person and prove they were negligent.
And the court's logic here is just perfect. The judge, Chief Baron Pollock, famously said, and I'm paraphrasing a bit, that barrels of flour don't just magically float out of warehouse windows. The event itself implies that somebody up there wasn't paying attention.
And that just illustrates the whole idea perfectly. The court sided with Byrne even without a witness. Why? Because for the first time, the law officially said that some events are their own evidence. The thing had, quite literally, spoken for itself.
Okay, so a falling barrel is pretty straightforward, right? One defendant, one warehouse. But what happens when the situation is way more complex? What if it's not just one person in control, but a whole team?
This brings us to a major American case, Ibarra v. Spangard. A patient goes into the hospital for a routine appendectomy, and he wakes up with a severe, paralyzing injury to his shoulder, something totally unrelated to the surgery. And here's the kicker, he was unconscious the entire time it happened.
So think about the plaintiff's problem here. He's facing this impossible wall of silence. He was knocked out, so he can't say what happened. There were tons of doctors and nurses in that room, any one of whom could have been responsible. And when he tried to find out what happened, they all just clammed up, making it impossible to pin down who was negligent.
So here's where the court did something truly groundbreaking. It applied res ipsa loquitur to the entire medical team. The reasoning was simple. The patient put himself in their collective care, so it was their shared job to explain how he got hurt. This was huge. It showed the doctrine was flexible enough to hold a whole group accountable when the victim is completely helpless.
And this gets to the real power of this whole doctrine. It's not actually about winning a case on the spot. It's about something way more fundamental to our legal process, just getting your day in court.
Right, so let's be super clear about this. Using res ipsa is not some automatic win. It's not a magic wand. The defendant can absolutely come back with evidence to show they were being careful. It doesn't mean the plaintiff automatically wins, it just means the plaintiff doesn't automatically lose, just because they don't have direct proof.
Its real job is to prevent a judge from throwing the case out right at the beginning for lack of evidence. Think of it like a key that unlocks the courtroom door. It gets the plaintiff's story in front of a jury so they can look at all the circumstances and decide, okay, was it more likely than not that the defendant was at fault here?
All of this makes a lot of sense, but it kind of makes you wonder, what's the deeper reason for a rule like this? Why did the law bother creating this special tool? What's the bigger principle of justice that's going on here?
And that brings us to the final and maybe the most important piece of this whole puzzle, the powerful reason why this whole concept even exists.
The whole doctrine really exists because of an information imbalance. I mean, think about it. In situations like that operating room or the flour warehouse, the defendant holds all the cards. They're the ones with superior knowledge of what actually went down. Res ipsa basically forces them to come to the table and explain themselves. It's a tool designed to, for lack of a better term, smoke out the truth and make things fair.
So ultimately, it's about leveling a playing field that would otherwise be completely lopsided. It shifts the burden of explanation, not the whole burden of proof, but the job of explaining what happened, onto the person or group who's in the best position to know. It makes sure an injured person who can't get that information isn't just left out in the cold.
So, the next time you hear about some bizarre, unexplainable accident, you'll know there's a legal principle designed for that exact moment. And it leaves us with one final thought. When the circumstances of an injury are so clear that they actually speak for themselves, who in a just society has the duty to stop and listen?